Okay, so we are going to talk about Rule 703. 703 talks about admitting the underlying facts and data that an expert used in reaching an opinion conclusion into evidence, particularly when those underlying facts and data are otherwise inadmissible. The big time this comes up is when it deals with hearsay. When you have inadmissible hearsay that is being relied on to reach conclusions, it's very complicated, but it's a very, very, very common objection. Everyone interviews people. Every expert almost has to rely on hearsay because very rarely are they actually present firsthand at the event. So they'll be given affidavits, depositions, specific documents, all stuff that predates or occurred during the incident they're asked to evaluate. But because of that, hearsay and experts relying on that hearsay is an interesting question. And when can you admit those hearsay statements to help illuminate the expert's conclusions? And how does that interact with the general hearsay rules? So let's just go and read the rule, and I'll talk a little bit more about it. An expert may base an opinion on facts or data in the case that the expert has been made aware of or personally observed. That just makes sense. An expert can use information they obtained through their investigation and coming to their conclusions. If experts in the particular field would reasonably rely on those kinds of facts or data in forming an opinion on the subject, they need not be admissible for the opinion to be admitted. So this is just talking about so certainly we know that it's not necessary for those underlying facts and data to be admitted, as long as those would be reasonably relied upon. But if the facts or data would be otherwise inadmissible, so this is talking specifically about things like hearsay now, the proponent of the opinion may disclose them to the jury only if their probative value in helping the jury evaluate the opinion substantially outweighs their prejudicial effect. Let's back it up. First, let's talk about admissible opinions. Very briefly, if you're making an opinion based on facts and data, you have free license to talk about the underlying facts and data, but it is not necessary if those facts and data are admissible and reasonably relied upon. Now, when talking about inadmissible facts and data used to reach conclusions, it has to meet this 403 test. So you can talk about the conclusion. No one is doubting that. It's not just that if a conclusion is based on inadmissible testimony, it can't be admitted. Far from it. In fact, if the conclusion is based on an inadmissible testimony, it may be preferred and mandated per the rules of evidence to elicit the conclusion without the underlying facts and data, which might just rub you the wrong way. Oftentimes, though, the plaintiffs in this case will want to use the underlying facts and data to help explain their conclusions because it makes it look even worse. So it would be one thing to say, well, I used Me and My Gun, or I used this comic drawn by Jesse Duran to reach my conclusion that he was violent. Perfectly allowed. No one can say anything about that as long as he's been qualified as an expert under Rule 702. But obviously for the plaintiffs, it's much more beneficial to have the specific content of that comic, Me and My Gun, and all of the drawings and depictions contained within, in the record, because it adds more credence to the eventual conclusion that was drawn. So this rule type tries to address situations like that, where there seems to be obvious hearsay. In the case of Me and My Gun, it's party opponent, but like let's say it was hearsay. I guess in this case, it's inadmissible for other reasons under Rule 404 character evidence, but you kind of get my point. The test that needs to be passed for this inadmissible evidence to be admitted under Rule 703 is a prejudicial versus probative test when it comes to whether the content of the document or the content of the inadmissible testimony or evidence, whether that inadmissible content helps explain the jury's conclusions, and whether that probative value, the helping explain, is not outweighed by substantial degree of prejudice. So taking Me and My Gun into example, if Me and My Gun, having the content of Me and My Gun certainly helps explain Dr. Couples or anyone else's conclusions. I think that's kind of not able to be argued. But what can be argued is whether that probative value is substantially outweighed by the prejudicial effect of admitting in all of this hearsay. I know that it's not hearsay, but assume I don't know party opponent. And that's an argument you can have. So when you're arguing 703, bring it back to the prejudicial versus probative test contained at the end of this thing. There's probative value here in talking about the specific content. If you were to get objected to 703, so let's say you try to bring in a specific instance of inadmissible content as evidence for an expert conclusion. They can say, the opposing counsel, that this is inadmissible, this is hearsay, whatever. It's essentially a response to hearsay or character evidence. Your Honor, I get that this is inadmissible, but because an expert relied on it in the course of his conclusion, then that's okay. And it passes, essentially, and what you're implying is that it passes this 403 test. The response then, so let me just break this down one more time, sorry. Objection, Your Honor, this is inadmissible hearsay. That's what you would say to me in my gut. Your Honor, if I may respond, this testimony is admissible under Rule 703 because an expert relied on this testimony in reaching his or her conclusions, and that's admissible under that rule. The response now for the person who originally made the objection has to be framed in the 403 realm, where, Your Honor, not any underlying facts and data can be admitted, only those which help explain the expert's conclusion and pass this 403 test can be admitted. And this specific piece of evidence, even if it was used in the course of reaching a conclusion, does not meet that 403 test, and as such cannot be admitted. That's kind of how the back and forth to this would go, and hopefully you kind of understand how these arguments tend to pan out. In regards to hearsay particularly, there is an incredibly important case law that exists in every single case. That's probably the most cited case law in mock trial, and it is based in real life as well. It's called Richards versus Mississippi Barbecue, and it talks about something called a conduit to hearsay. It almost adds another necessity, another prong to 703. Not only does it need to meet not only did it need to be used by an expert, and not only does it need to help explain their conclusions and pass this 403 test, but it also needs, in the case of hearsay, to have had scientific technical data applied to it. Namely, and the phrase used here is conduit to hearsay. So just because an expert looked at a piece of hearsay and came to conclusions does not mean that there was a causal connection between the two. There needs to be a clear demonstration of an application of facts and data, or principles and methods to the fact or data you want to get in for it to get in under 703, especially if it's hearsay. If not, then they're just a conduit to the whatever inadmissible testimony, and it's still inadmissible. So be careful for people doing that. Be familiar with both the rule and the case law, and hopefully that gives a bit of explanation for those of you who are directing or crossing experts out there. Thanks. Next, we're going to go on into opinion on the ultimate issue and hopefully wrap up experts pretty soon. See you guys.